Hi, this is Matt from the HMO platform, and welcome to part 4 of this 5-part series where we've been talking with Tej. This one's a little bit different because it's going to be a bit of a presentation from myself. Tej and I have talked about the contents, and it's talking about the paperwork that's required when raising finance, the types of things to be aware of. We're not going to be looking at the actual paperwork itself because that's down to your particular circumstances, down to the deal and the agreements that you've got with your investors or joint venture partners, but look at the overview of what you need to be aware of. So the first thing is that actually you can only raise finance from someone who is a sophisticated investor or a high net worth individual. This is really important to understand. So this is defined by the FCA and governed by the FCA, which is the Financial Conduct Authority. And there's plenty of help and advice on their website, which is listed here, handbook.fca.org.uk. So you have to be careful when raising finance and just make sure that you're speaking to sophisticated investors and high net worths. And one piece of paperwork that would be a good thing to get signed is a self-certified form from your investor to state that they are happy, that they understand that they are a sophisticated investor or a high net worth individual. So that'll be the first piece of paperwork to get signed. Following on from that, you need some other bits and bobs. So if you're borrowing money to do a property project, whether you're borrowing money from a company, from an individual, from a pension fund, it's always going to be backed up by a loan document. So that loan document is the first piece of paper. Now, I've seen loan documents being 2 sides of A4 and I've seen them being 30 pages long. At the end of the day, that loan document, that piece of paper is there in the worst case scenario. So if something goes wrong, what was agreed up front. And solicitors will write in lots and lots of ifs and buts, etc. So it really depends on the attitude to risk from the investor, probably, as to how much they want to have written in this loan document. So that's the one piece of paper that you definitely need when you're borrowing money to do a project. Now, in this loan document, you might specify which project it's for. You might specify that it's a loan for your business, to go out and buy property in general. There are many ways that you can do it. In fact, all these pieces of paper are blank pieces of paper to start with, and it comes down to you and what your investor and your partners are looking to achieve. Now, if you are doing a joint venture with someone where you're splitting the profits, then you'll want a heads of terms document first of all. Now, this heads of terms is a kind of a plain English document where you just bullet point who's involved, who's doing what, who's providing what, and what the outcomes will be. But also in there, you'll think about what if. So what if one party was to pass away during the project? What if one party was to go bankrupt during the project, or on another project? So you need to be aware of these things, and that information will go in your heads of terms, and then quite often you then give that to a solicitor to draw up a shareholders agreement, which will form part of your incorporation of your company, your joint venture company that goes out and does that project. Your joint venture could also be a partnership, so it could be a partnership agreement instead of a shareholders agreement if that is done in your individual names, as opposed to doing that in a company. So where do we go to get this paperwork done? Well, there are lots of templates that you can find which are used documents other people have used. Now, that might be okay, but is it fit for your purposes? It's definitely fit for the purpose for the people that have used it, one would hope, but is it fit for your purpose? But you can often use a template to put a loan agreement together or a joint venture agreement together. Then you might go then run that past a solicitor to then get that okay to make sure that it works for you. There are also online legal document portals where you can get legal documents created online. Again, if you're going to use that, if you're trying to save money on this part of the transaction, maybe get that done and then give it to a solicitor to check to make sure it is fit for purpose. Alternatively, as we said before, get your heads of terms together and then give that to a solicitor to draw up. But the best bet is to get independent advice for each party and get a solicitor to draw it up. But that will be the most expensive way. So if you are trying to save money, maybe use one solicitor who represents both parties following a heads of terms. So a few different ways of putting that together. Now, your investors and joint venture partners will probably want some kind of security, and there's a list of things that you can give. So your loan document itself is a form of security. And in fact, some investors are very happy just to have that loan document, as long as that's in your own name and you've borrowed money to yourself, then that's enforceable in the courts. People can come after you for that amount of money if you've borrowed. So that loan document gives that investor security. If that investor is invested into a company, then you as the developer may have ring-fenced your security in that company. So that works quite well for you, maybe less so for the investor, because if the company goes bust, then they can't come after you for their money. So a personal guarantee sometimes is put in place between you and the investor, just so that if the company or the project does go south, then it means that you're honouring your agreements to pay them back from your own personal proceeds, not just from the company. So that can be put in place if someone is lending to your company. Now, if an investor wants to have security over an asset, you can do that in a few ways. You can have a restriction over a property. This is done using a form called RX1, and this just restricts your ability to sell or refinance an asset that you've got and the investor would then have a certain amount of control. They can't do anything with it, but it means that they can stop you from doing anything with it yourself. So it's quite a nice, easy way of giving someone a bit of security without giving them the charge over the properties, which is the other things that you can do. So the bank will normally take first charge, and a lot of banks will allow a second charge as well, on top of that, subject to certain criteria. So a solicitor would be involved, and you would give your investor a second charge behind the bank who's the first charge lender. Now, you will need something called a deed of subordination, which means that it's an agreement between you and both of the companies that have charges, to state that state who is in order, what's the pecking order for that particular project. So when it gets sold, the first charge gets their money first, second charge gets their money, then everyone else gets their money after that. That's essentially what would happen, and a solicitor would do that for you. Now, you can give a first charge over the property. So if someone's lending you all of the money, it might be high net worth lending you all of the money to do a property project that you're going to do and then sell and then split the proceeds, etc., then you might give them first charge as security. That is a job for a solicitor to do. They would have to register that charge, and you don't want to be doing this on a regular basis because it is regulated. So ideally you want to be a regulated lender to be taking first charges on properties. Every now and again would be okay for a first charge on a property, but again, speak to a solicitor before you do this. And again, another thing you can do is give people shares in your company. Again, that would be a joint venture structure, so someone could come into your company to give an element of security, where a bank might take a first charge. So many ways that you can structure it, but again, coming back to your solicitor will be the first point of contact. So there we have it. That's an overview of the finance documentation that's required. If you do have any questions about that, you can post them below, or alternatively go speak to your solicitor or your broker who's FCA regulated, and they can give you advice as well. Some banks will allow you to use investor money, other banks will not. So just be aware of what your bank's requirements are when you're doing projects as well. Thank you very much, and see you in the next video.